Hello, everyone. We're back. In this second of three video lectures, we're going to talk about not just laws in general, but we're going to get into more of the issues involving healthcare compliance and health information. So let's take a look. Okay, so we talked a little bit about the defendants and the countersuits and all these other things that can happen. But another important thing is before we even go to trial is the discovery. And there are different discovery methods, one of which is a deposition, where somebody is brought in to tell their side of the story, right? So they are deposed. Okay, so as part of this discovery, we have requests for production, we have interrogatories, excuse me, and depositions or depos, as my legal friends like to call them. They all kind of sound the similar, but they all do similar things, but there are some important differences. A deposition is somebody comes in and under oath answers some questions. They're deposed, if you will. Interrogatories are basically answering questions in writing. So it's similar, except one, you're verbally answering questions, one, you're answering a series of questions in writing. And then finally, requests for productions are basically asking for documents, say in our case, medical records. And we have different discovery tools, meaning that the court wants to have people respond to what they want. And one of the most common is a subpoena, right? Subpoena ducis tecum, meaning I'm summoning you and documents to come to court. We can also get a court order that's been in the news on a regular basis lately, and a search warrant, right? Where the court says, in order to see if we have a case, we're going to be needing these types of things, right? And then, of course, you have the e-discovery. So basically, the parties can obtain and review electronically stored data. Should add here that includes electronic health records and also includes metadata. In other words, data about data. So things like email, all these other things are discoverable, to put it in legal terms. And United States Court, this is governed by the federal rules of civil procedure. So there's certain data that is discoverable, and there's certain data that is not discoverable, right? So incident reports are generally not discoverable, right? That's why in a paper chart world, we made a big deal about making sure they were not filed into paper charts because you can subpoena whatever's in the chart, and if it's there, it's fair game. So finally, the last two bullet points we have here is legal hold and spoliation. What are they and what they mean? A legal hold is basically an instruction that all of these documents, emails, data, where we're having an investigation or a court action is to be preserved. Spoliation is the destruction or the alteration or the failure to keep something despite a legal hold. Then, of course, we have the trial process. And again, we covered what civil and criminal is. We can have a jury or a bench trial, and certain pieces of evidence are considered admissible or inadmissible. All right. And if you ever watch things like Law and Order, we get into things that if somebody gets a murder weapon and they have DNA on it, right? and they can see whose DNA it was. If they obtained it without a proper warrant, that is deemed inadmissible. And then, of course, we have the collection of judgment or the sentencing. We do the collection of judgment in a civil case. We do sentencing in the criminal, and then we can have appeals. And within U.S. court system, we have federal rules of evidence that govern what's admissible in a court. Generally, hearsay is not admissible. Hearsay is an out-of-court statement that's used to prove the truth of something. There are certain exceptions to this, and health records are admitted through the business records exemption to the hearsay, right? So if you keep health records as a normal course of your business as a healthcare organization, those, even though they're out of court statements, they're not actual, you know, privileged types of things, they're business records, those are considered admissible. Privileged communication is protected from admissibility, and this would be things such as quality improvement meeting minutes, right? Those typically are not allowed to be introduced into court. They're considered privileged communication. Communication between an attorney and their attorney and a physician is considered, for the most part, protected, privileged communication. So, what does professional liability mean and causes of action? Well, basically, we're looking at who's responsible for something that harms somebody, right? And so if there's a harm, there's a tort, right? And they're different intentional torts, but the one that we're most concerned about typically is negligence. In other words, failure to provide a minimal standard of care is an example of negligence. And when we use the broad term medical malpractice, we're talking about professional liability of a healthcare provider. So in other words, a standard of care, if a physician did not provide it and they were trained, should have known, should have provided it, that's what we're talking about with medical malpractice. We can also have such things called breach of contract. In other words, we have a contract, right? And you can even see this with physician offices and insurance companies. You said you would reimburse us this amount of money for these types of services. You failed to do so. As a result, you're in breach of contract, and I'm going to sue you for damages. That's an example of that. And some of those have been in the news here in Oregon recently. If you're interested, please reach out and I'll share exactly what I mean. Okay, so again, we have different types of negligence. There's nonfeasance, misfeasance, and malfeasance. So what do these all mean? Okay, so these all sound very, very similar. They all have feasance. They all have feasance in them. They're all a little bit different. Nonfeasance means failure to act when there's a duty to do so. So if taking it outside of the healthcare realm for a minute, if we have a city inspector who ignores a dangerous building code, like the Millennium Tower in San Francisco, for instance, and does nothing, and then people buy office space or living space in said tower and they suffer economic harm, that is nonfeasance. Misfeasance means you did something legal, but you did it wrong. You did it improperly, and it caused somebody harm. So, an example of that is a nurse administers a medication, legal act, but issued the wrong dosage. And as a result, that is misfeasance. Now we have malfeasance, and this is intentional wrongdoing or unlawful conduct. We see this a lot lately in the news where people are in certain government areas. This is very, very common. Government officials accepting bribes. We had somebody in the city and county of San Francisco who worked in the building department who is accepting bribes and is on his way to prison. So that's an example of malfeasance. To have the elements of negligence, you have to have a duty to meet a standard of care. So if somebody goes into a 24/7 emergency room, they have a reasonable expectation to expect that there'll be a qualified emergency room physician to take care of them. Then you have a breach, right? So you have essentially a failure to meet said standard of care. And then you have to have causation. This is basically cause and effect. Because of somebody's breach, I was harmed. So unless you have all these elements of negligence, you don't really have a case. And again, when we talk about causes of actions, physician-patient relationships, it's based on a contract. It's express and implied, right? So if you go into the emergency room, you're not having the emergency room physician sign a written contract with you saying that you have a duty to care for me under these conditions up to and including X, Y, and Z. It's understood, if you will, right? And last slide for this, patients' rights involving healthcare decisions. One of these is very important, which is the first bullet point. This is consent. We can have general consent and informed consent. Informed consent spells out the potential benefits, risk, and so on and so forth of, say, a procedure, and it kind of delineates it. General consent is just that. One of the other things, if you've ever been admitted to the hospital, is they get into advanced directives. These are durable power of attorney for healthcare decisions. So, in other words, if I'm in the ICU and unable to respond, who will respond on my behalf, right? Could be your spouse, could be your parent, partner, or what have you. But this is what advanced directives do, right? Related to that are living wills and DNRs, which means do not resuscitate. And that is something that's tied to this. And sometimes you'll see these delineated saying that I do not wish to be intubated if I don't have a reasonable chance at a complete recovery, so on and so forth. So again, you can think of living wills and DNRs as being subsets of advanced directives, right? So an advanced directive is kind of the global term. Beneath that, we have an advanced directive that's a durable power of attorney that allows somebody else to act on your behalf in case you can't. A living will, which again, another type of advanced directive. It's basically a legal document that allows a person to state their wishes about medical treatment, right? And then the DNR order, which is an order saying that we're not going to resuscitate somebody if they need it based on their wishes. And that's all I have for you. Tune in to the next video lecture. We're going to be discussing things such as HIPAA, advanced directives, and more. We'll see you then. Bye now.